This is an unfortunate situation we're dealing with today, particularly because it deals with a former colleague. And that situation has been made worse by the amount of dust that's been kicked up to try to distract us from the facts. So let me spell out those facts. The Select Committee sought records and testimony from Mr. Meadows because we believe that he had information relevant to our investigation. He reportedly participated in or witnessed events that are the focus of our work. So on September 23rd, we issued a subpoena for documents and his testimony. After weeks of back and forth with his lawyer, evidenced in the letters we made public with our report, we set a November 12th date for his appearance at a deposition. At that point, he hadn't produced any records, and when the time came, he didn't even show up. We signaled at that time that we were prepared to move forward with contempt proceedings, but we also gave Mr. Meadows a final opportunity to reverse course. We set another deposition for December 8th, and Mr. Meadows initially agreed to provide testimony. Now, throughout this process, Mr. Meadows' attorney has raised claims of executive privilege and so-called absolute immunity. The idea that individuals who hold or held certain positions have no obligation whatsoever to appear before Congress when called. We don't accept those claims. President Biden hasn't asserted executive privilege or absolute immunity regarding Mr. Meadows' testimony. And all the courts that have considered claims of absolute immunity have rejected them. But all that discussion about different privileges is a distraction. That's not what this contempt referral is primarily about. This referral centers on the information that even Mr. Meadows and his attorney says is outside all those claims of privilege. He provided roughly 9,000 pages of records that he and his attorney freely admit cannot be held back by any sort of privilege claim. They gave us a lot of this information. His participation in a January phone call aimed at pressuring state legislators to overturn election results, that's not protected by executive privilege. His communications with Georgia Secretary of State regarding efforts to disrupt election, that's not protected. The list goes on, and while the records he handed over gave us valuable information, they also raised a lot of questions. And then the day before he was scheduled to appear for his deposition, he changed his mind. He said he was through cooperating with our probe. He refused to come in and answer questions about the non-privileged material. He has no basis to refuse to cooperate on those matters. That alone is sufficient to advance the referral. But for the sake of argument, let's talk about Mr. Meadows' privilege assertions. The Select Committee isn't able to assess whether Mr. Meadows is making those assertions in good faith because he won't even come in and address them on a question-by-question basis as he's required. I have my view of whether he's made these claims in good faith because I've seen him on television talking about his conversations with the president and promoting his book. I understand that this is a difficult matter. I have no great desire to be here seeking consideration of this contempt referral. Mr. Meadows was a colleague for more than 7 years, but that doesn't excuse his behavior. If anything, his time as a member of the House should make him more aware of the potential consequences of defying a congressional subpoena. We've given Mr. Meadows every opportunity to cooperate with our investigation. We've been more than fair. He's brought this situation on himself, but there's no doubt in my mind that he's in contempt of Congress and has to be held accountable. I thank you, Mr. Chairman, for allowing me to open with these comments, and I look forward to your questions and yield back.